The first one, my lord, is that there was a sitting on Saturday, which the court has explained how that sitting happened. With regard to that sitting, my client wrote a letter to the owner, which has been placed on record in an affidavit and an application before you, that Professor Nyamansa, that in practice, in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights. It's a practice that is prohibited under the 20th. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what she's about. But we now learn, Your Lordship, that you are convened by the Honorable Justice to get the Chief Justice. My Lord, arising from that, one, a legal issue and a matter of attitude. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issue, the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under 247 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday, I think I have arrived to raise those issues.
So that even we taking notes, know what we should be responsible. That's what I want.
Professor Bulgai was a former attorney general. The point is that we should be I am asking for specific
Check it. Kill it. Check it. Kill it. Check it.
Yeah, but we are trying
addressed you pursuant to Attorney General's Act Section 7, which provides that you take precedence. We are happy with that.
There's no objection, that is the correct position.
Thank you.
So, yes, I was going to request you that we take the quorum first. I'm Dorcas Igor, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Gideon Mugai, Senior Counsel. Shadrach Mose, the Solicitor General. Emmanuel Dieter, Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Dieter.
Where is he?
I'm present, Your Honor.
And Charles Mutinda, Deputy State Counsel.
Present, my lord. Present.
For the National Assembly, we have Eric Zumbo,
I'm present, my lord.
Paul Nyamodi,
Present, my lord.
and George Murugara.
Present, my lord.
For the Speaker of the National Assembly, we have Benson Milimo,
Before you, my lord.
Josephat
Just make it
Miyoni.
too fast.
Oh, sorry,
You introduce Mr. Mugara.
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo,
I'm present, my lord.
Josephat Miyoni.
My lord, I'm present.
Just for who?
Kuyoni. Kuyioni. For the Senate, we have Professor Ojenda Tom, Senior Counsel,
Present.
Moni Mukele Edwin,
I'm present, my lord.
and Senator Hilary Sigay.
I am present, my lord.
Money who?
Moni Mukele Edwin,
And Professor?
and Senator Hilary Sigay. That is for the Senate. For the Speaker of the Senate, we have Mercy Tanji, and Peter Wanyama.
I'm present, my lord.
For Professor Kindiki, CS, and DP nominee, we have Mudomi Yankolu,
I'm present, my lord.
Moses Kipkosgei, and Ken Meli.
Present.
My Lords, your leadership, in petition 565 of 2024, may I, at the very outset, before I state, counsel appearing, the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, and we will elaborate. But let the record show that counsel appearing for the Deputy President today before this honorable court appear at the protest. As I say, the basis will be elaborated later. I appear, or waited for the record, I appear with my colleagues, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Swanya,
Present, my lord.
Nebo Wanjiru,
I am present, my lord.
Andrew Muge,
Please, we are recording the program. Faith Waigwa,
Faith Waigwa, Victor Swanya Ogeto. Nebo Wanjiru,
I am present, my lord.
Andrew Muge, George Wandati, Mr. Sakim Pa, and John John.
Present, my lord.
My lords, your ladyship, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether they are any other petition. I thank you.
We will take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and others requested the National Assembly and 5 hours.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the respondents is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Just for the purposes of clarity, just will record the quorum fully.
Dorcas will appear as the Attorney General. For the Attorney General is Professor Gideon Mwigai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For the National Assembly, Eric Gumbo, Paul Nyamodi, and Mugala George. For the Speaker of the National Assembly is Benson Milimo and Josephat Milioni. For the Senate, Professor Ojienda Tom, Senior Counsel, Moni Mukele Edwin, and Senator Hilary Sigei. For the Speaker of the Senate is Mercy Tanji and Peter Wanyama. For His Excellency the President, Adrian Kamodo. For Professor Kindiki, he's an interesting. Mudomi Piankolu, Moses Kipkogei, and Ken Levy.
Your Lordships and Your Lordship, my name is Kipe Mongai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Present, my lord. Your name, please.
My name is Kipe Mungai. I thought I'd said it, my lord. Kipe Mungai. Sorry. I appear in this matter, my lord, with Senator Daniel Manzo.
Present, my lord.
Mr. Ndegwa
I'm present.
Honorable Jerry Maina,
Present, my lord.
Mr. George Sankimpa,
Present, my lord.
Mr. Andrew.
Mr. Kibe.
Yes, oh, sorry.
We are recording.
You are recording. Sorry.
Can you start from Dan Manzo?
Dan Manzo, Mr. Ndegwa
Present, my lord.
Senator Honorable Jerry Maina,
Present, my lord.
Mr. George Sankipa,
I'm present, my lord.
Mr. Andrew Muge, Mr. Kirago Aduta,
Present, my lord.
and Mr. Kenneth Matiba, who is on the way, and Professor Ogada. Professor Ogada.
Present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024, that appears to have been filed on the same day
So you are here for which party?
we appear for the petitioners in that.
Lord, Your Ladyship, this petition E015 2024, Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. My lords, again, let the record capture and show that counsel appearing for the first interested party appear under protest. Counsel are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Soanya, George Wandati, and John.
Can we have that again
Yes, I'm sorry. From what point, my lord?
from yourself?
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigwa, Victor Soanya Ogeto, George Wandati, and John. At the appropriate time, we will be going into the grounds and basis for appearing and approaching.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My Lord,
Before we start the moves on that part, are there other files, especially file number petition E572, 2024, is it before the bench?
We'll take programs of the files which are before the court and that you can raise any issue.
My lords, may you kindly equally confirm whether E0, E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
My Lord, that matter is not before the court.
Your Lordship is being called, it is the call that you know whether it is before the vote.
We had a
We also want to know whether it is before this.
My Lord, so, my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether I can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it should come up actually tomorrow. And I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today. So I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. Raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Wambi, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word oil. That is the file that was called. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of the employer, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you. And John,
we have that again.
yes, I'm sorry. From what point, my lord?
From yourself.
Paul Muite, Tom Macharia, Elisha Ogoya, Faith Waigwa, Victor Soanya Ogeto, George Wandati, and John. At the appropriate time, we will be going into the grounds and basis for appearing as a protest.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
My Lord, before we start the moves on that file, are there other files, especially file number petition E572, 2024, is it before the bench?
We'll take forums of the files which are before the court and that you can raise
any issue.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimodo Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
My lord, that matter is not before the court.
Your Lordship is being called, it is the call that you know whether it is before the vote.
We had a
We also want to know whether it is before this.
My lord, so my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether you can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it will come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. Raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Wami, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kerugoya. That is the file that was called. And in order for the record of this code to be systematically accurate, and easy to follow. May I, with respect, ask that we get clarity on this file that was called out E13/24 of the lawyer before we go to the other matters. Perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This.
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number A0113, which was consolidated in Kilgoya before it arrived here with A0114. 011414. Then we have application number E0115, also from Kilgoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you there are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we welcome it. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kilgoya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kilgoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kilgoya or in Nairobi?
Let me deal with that. Lord, for the purpose of A572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the one to take that petition was filed on 18th of October. The same day the Kilgoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are borders. The reason as to why Kilgoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
If you could mourn elsewhere. My lord, I had indicated to this honorable court that there will be at least 3 clarifications.
Just a minute to something.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that they are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My lord,
just a minute, please.
Perhaps just to add that it's the numerous other petitions that are coming up.
Yes, my lord, I believe now I can be able to make the clarification. Yes, my lord, I believe now I can be able to make the clarification. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first. There's a quorum there's a quorum in E013, which was consolidated in Kergoya with E014. Let's take quorum on that file.
Your Lordship, is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not heard it, perhaps it will be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The direction from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Kerugoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kerugoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Mr.
My Lord, may I say something?
Let me answer you. You said that record speak for himself. And for record, matters which came from Kerugoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these 2 files. So let that not be an issue here. On the directions issues on 11th by Judge Richard Mongo, these were the directions. The petitioner in E014 2024 to serve their amended petition on all parties. Similarly, the petitioner in E013 2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to the Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume now we may now raise the issues that you want to raise, particularly arising from the issues in Keroya. And I
We
do
will
not
then
know.
proceed and take forum on if they were consolidated, so we will not take further forum on this matter.
The Attorney General, I don't know, I have indicated to the court and I need to raise some clarification. You had already asserted. It doesn't override my right to represent my client. Can she then say her piece, I say mine?
Now, which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that
Yes.
the only matter they were filed before impeachment and they have been covered we have E15.
E15 has to.
But E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservative member.
I hope I have dealt with her without further appearances. My Lord, my Lord, I'm leading the number of advocates in this matter from Kenyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on the record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice William, the Deputy Chief Justice. Lady, my Lord, arising from that, one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may
I think I have a right to raise those issues.
let's give Fellow Mugai time.
Mungai, Muigai.
I just wanted for good order.
Okay,
my lord.
is that a
If I may.
clarification, Mungai?
Muigai. My Lord, I am Mungai. I believe he will speak in response as soon as I'm
Proceed,
done.
proceed.
Then we finish.
My lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted
My
to
Lord,
say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's before the court. I should be having silence. He will respond. And I've indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Nguruma has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that background that we are giving. My Lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My Lord, under the former constitution, my Lord, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But not because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made last time. And my Lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
Let us be discharged the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My Lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue is speak for the wananchi and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable,
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that then does not have to do with those prayers. But the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged our administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, effective.
Petition E13 and E14, Gachagua.
Yes, it was consolidated and we were told that
Just to add on what my learned friend has said.
however, we were not notified. I just learned of it today on the TV at 11. So we had to rush.
I wish to
And perhaps clarification purposes.
the matters which are before us today.
Is there anybody who has been left out?
Are not here on the basis
A commission,
Yes.
just to draw to the court's attention, there is an application lodged
I have stated and I'm repeating.
United Democratic Alliance, which can be considered as an appropriate stage. Thank you, madam.
Interested party or interested party?
He's an intended. He has not been joined as yet.
And on the parties,
Yes.
in this petition, I'm assuming it's one of those that you have mentioned, 528 of 2020.
We have not mentioned that petition, and on that score, let me say this: that they mentioned different petitions which were not before us. I think we should be very clear that we can only deal for us to mention any matter which is not before us and which has been placed before us. We shall make that communication. So I think we need to be very clear that jurisdiction is prescribed to particular files. Thank you very much.
My lords, your leadership, permit me to request that the E565, in which the deputy president the petition, and E015, interested party. Let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. The record, the court has acted of its own volition and the normal practice, even under the Mutunga rules, is to accord parties to state their views on a proposed consultation. This is the court's rule violation. We were not asked to give her. Thank you.
Your Lordship.
Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem you are trying to address in the morning, Your Lordships. That now this bench has created 2 lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Ndegwa, there is absolutely no confusion in these matters. Let us not bring confusions where there is none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
My lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that proposals. First, we would like, my lord, having read what has been arguments and facts. And I draw you to paragraph 5. They say that that terrible code recuse itself. It would be gravely serious to the response. If they were allowed to prosecute this application, take a second bite. We would like to argue both of them to allocating time. We are going to have another long approach. We are willing to say in advance that whatever time you give us, each we will accept. You directed my lord in the morning.
Yes.
Yes. But it is in that application that has been advocates. That is the application that seeks, on the one, the second hand, requires the recusal of this thing.
It is one application.
It is one application.
There are 3 applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes.
I just, my lordships and my ladies, wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals, and 159(2)(b) justice shall not be conditions and let us move forward. Thank you.
My Lord, the best that we could in terms of complying with those directions needs to be gagged on the issue of time we protest. We shall require sufficient time are as different as UDA can be from purposes of the difference. The application under Article 165, because we've had to include their earlier complaint in the morning.
Lord, I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right for it. My lords and my lady, take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of under Article 165, because in the morning when we raise the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need grounds. We just need sufficient. Let them prepare authorities to argue on the issue of recusal. When you are given so, my lord, we cannot be able to argue. We cannot be able to argue as expected by our client. And there is no similarity to issues. Therefore, my lord, I urge you.
For recusal.
There are two applications.
Where are they?
I know, Gachagua, you mentioned one. I believe yesterday, 21st of October, there is another.
Okay, Mr. Mugai, these are the directions we are making. The application is the application. And perhaps my lord before.
Building a website should be free and easy. With our drag and drop editor, no coding is needed to build your website. Choose from hundreds of free templates available with portfolio, membership, and e-commerce features.
She was not aware of directions in the morning that applications and we come back before you, integrated for you, integrated in
Council, listen to this. Us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with, dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. on the issue of time allocation, Judge Ngoreba will give the final issue directions on time.
This is how we proceed. The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves of the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The clients I and my colleagues represent, the deputy president, is the subject of the removal of the subject of his pleas to this court. For him not to be. The application for the constitutional bench is made in E015, as my friend given me, so that effectively the subject matter of the removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. Out of 6.
You have 10 minutes. You have 10 minutes.
Yes, yes. Dr. Kamuna, we please, you are not audible.
Oh, I'm sorry, I speak now.
Yes.
I received the instructions yesterday from the project here that I come and make an application that
Video editing is hard, and it takes away your precious time. Don't be like this guy. Just use VideoGen. VideoGen generates videos for you using cutting-edge AI technology. Go from an idea to a
Syria has played in advancing the prudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen for a number of things which I may not be able to say if I'm representing the position.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing? My lords, the country is not crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so, with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my honorable friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What? I think Dr. Kamuna.
I have taken the trouble to read this constitution of Kenya. I have taken the trouble to read constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kamuna, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to us give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya. You don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Kamuna, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the we talk about time in civil matters and so. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is touching the whole nation. It has paralyzed the nation.
We have heard you, Dr. Kamuna.
Let Paul Mwite be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutaji Makinata, before and buried the Matako New. Let us forget about time. Where are we going?
My Lord,
where are we going with
Dr. Kamino?
With respect, would you speak to that? Kamino is talking. Would you sit down? I am talking.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel.
I will not speak down. We're not practicing law. You're still doing breastfeeding.
That is also. So, my Lord,
my Lord, what
Dr.
I'm saying,
Kamuna, finish what you're saying.
What I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we heading for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to this.
I think they mean something, Dr. Kamuna. They do mean something.
Something means something when it's you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Camilo, you have made your point.
Yes, thank you very much.
You have made your point.
I have made the point.
Professor.
We have a Chief Justice who has been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior PK Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Camilo that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empowerment. That's all I wanted to clarify.
So, Dr. Camilo, I've heard what you said. We'll stick to the time allocation.
Use PDF Filler to edit documents anytime, anywhere, from any device. Add text anywhere in the document. Use the eraser tool to erase anything on the form.
In view of that time allocation, and I thank senior counsel, the senior most going by the Kenya law reports before you. May I beseech your lordship,
my name.
Dr. Camino.
Thank
you. My Lord, even the report of the East Africa Law confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of this application. My colleagues, Professor Ogada, and my colleagues, Ndegwa and Jiro, within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Ogada and Mr. Ndegwa and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me, indicate 20 minutes to do a review. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that does not change any time allocations by more than 30 minutes. So I urge you not.
So who's starting?
I'm starting. Okay. Yes. So that I do 20 or gather 20 because he has to deal with some authorities. I didn't get enough time. Then I'll do the rejoinder. But the application that is before you is dated today. It is supported by the affidavit sworn by. It is supported by the affidavit sworn by Honorable David Munyi Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions because I believe there will be no time for that. So we act for all the respondents, for the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seem to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days and for Parliament to do it within 60 days somehow happened within 4 hours. My Lord, those are why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intent of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, leave those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my lord, and there are a lot of matters that directions must be given. So that, my lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my lord, I come to the prayers. The prayers are like this, and we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the Constitution, members of a certain court to hear the matter. My lord, Article 165(4) is very clear. Where the Constitution says the President, and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and work under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madho versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my lord, all these cases we are aware of. So that, my lord, as far as Article 165 is concerned, we submit that that is not possible. But, my lord, this argument is developed a little bit further by the petitioner's applicants. Because the petitioner's applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do two things. One, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. But those are irregular, because as we are saying, this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan would be aggrieved by a decision made in these circumstances, would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the Constitution and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast track that hearing. But my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My lord, that being the case, there has to be satisfaction. The Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our constitution, I deal with Mutunga rules every day. Petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But my lord, where the Deputy Chief Justice chooses to fast track the grievances of the alleged violator, common sense has to be affected. My lord, the conscience of this court must be bothered. Such conduct, in the normal sense of things, we went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But my dramatic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that my lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to see, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordships. We have done very many matters. You have courageously stand up for the constitutions in various matters, but my lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitution. My lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this was the context in which this matter must be viewed. My lord, there are certain authorities, my learned colleagues will go through them, but I need to mention at least two things. My lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying this is administrative. That decision is not binding. But my lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and I believe it is a case of Okoichi Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleague, so that it can be faster, I don't want people to knock me. My learned friend can do her. Let him do his 10 minutes, then you can do his 10 minutes.
Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in the exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, we all write that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, your lordship, you seek leave under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution, for and on behalf of the people. That article again clearly indicates that this power under Article 165 Clause 4 is not capable of being delegated. How about, Your Lordship, in the Constitution? Your Lordship, I invite you to look at Article 160 or 260 of the Constitution. It provides if a function has been created to be executed by a particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your Lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they moved to appoint a bench of this, the bench, and failed to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells Your Lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mongo and your brother Justice Mwita. Your Lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Administration Act, how, under what circumstances the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your Lordship, is our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is ordered out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request counsel to give us specific reference to Okio Matata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya, so we don't know which of his many cases are you referring to.
I will certainly be
addressing my senior at the bar and senior at the academy, Professor Gideon Mugai. It was a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated. In the BBI case, David, Lee, and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition, they raise a case, Lorna Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. That the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gideon Mugai was asking about. Paragraph 2938. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165.4, the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259.3a that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259.3a. I'll want this court to consider the decision of the Court of Appeal, and this
The other side can take judicial notice of. The court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. Such that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, honorable court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. It's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
My lords, my ladies, I stand here to argue the supporting arguments for the first substantive petitioner, His Excellency, the Deputy President. And in the 10 minutes given to us, I will take 7 minutes and leave 3 minutes to my learned senior colleague, Senior Counsel Paul Mwite, who in his to take the lead in arguing this point. Allow me to begin by juxtaposing 3 constitutional provisions, then pose the challenge that I will ask my lords to retire with for purposes of your consideration. The first is Article 141, Clause 1 of the Constitution. Article 141, Clause 1 of the Constitution provides, and I read, that the swearing in of the President-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. It's very clear. It says who must do and what will happen in the absence of that person. Article 148, Clause 4 of the Constitution provides, and I quote, the swearing in of the Deputy President-elect shall be before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. And in fact, another very clear stipulation of our Constitution of what the Chief Justice can do and what will happen in the absence of the Chief Justice. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lord, my lady. You notice that Article 141, Clause 4, Article 148, Clause 4 come before Article 165, Clause 4. The makers of the Constitution were aware of what would happen in the absence of the Chief Justice while drafting Article 141, Clause 1, Article 148, Clause 4. Let us see what they said at Article 165, Clause 4. They said, and I quote, that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. Full stop. I'm always encouraged by an article my mentor, Professor Gachagua, wrote many years ago called Political Jurisprudence or Neutral Principles. Another look at the problem of constitutional interpretation. And Professor Gachagua makes an important argument that decisions of constitutional courts must be formulable in such a manner that they would apply coherently to all subsequent cases of similar facts. I'll not read these names in full, but you now know that if we approach this court and read for it Lena Conchella, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Montata, both of which have been referred to by my learned colleague Mr. Gada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Guido Mwiga, would frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first-year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that will address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Ontata, constitutional imperative, and what Conchella says, administrative. But then you look at the eventual verdict in Conchella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's a limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, you know, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, Kenya, wherever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Conchella decision, none of the preconditions cited there to justify the limb of administrative has been met. In which case, the Deputy Chief Justice has no basis upon which she could have taken up the charges to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I will be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. That's why we need this argument. But the interface between litigants and the judiciary in this technology space is the CTS, the e-filing system. There are no directions from the Deputy Chief Justice in the e-filing system that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role in that direction. we ought to have seen a decision saying, for the following reasons, I take up this role of the Chief Justice, then proceed to give direction. In the absence of that step, my Lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the deputy chief justice in the eye and say, you may have been well-intentioned. You are. You fell short of the constitutional standard, and therefore, by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleagues, senior counsel, permitted to carry forward and finish our arguments. And thank you so much.
I will be very brief, Lords, Your Ladyship. The taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya, presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your ladyship to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemable. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordship, your ladyship should, on the basis of those irregularities. Down there. There is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularity, this honorable bench found time to give a hearing today when they say they are only available. Let justice be seen to be done. The only urgency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition was very weighty issue in order to swear in somebody somewhere. Yes, you are concerned with the Constitution. permit me to point out with a lot of respect, my Lord, to your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary. Only preserve that. Right.
May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank
to find out whether we are with the form weaker or not.
Yes, how many people are supporting the application?
In number 15.
Are you parties in this matter?
Yes, we are consolidated. So there's a petitioner, the second petitioner, who has. For the second petitioner, with the support of the application.
Your name?
This is Kemoto Teresia Wanjiro from Test Kimoto and Company Advocates. For the second petitioner. Yes. So perhaps if I'm also allowed to submit or go to. Okay, thank you. So, the owner in support of the application, the fact of the matter and why we are in support of it is number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before the judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or will we be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders you got from Gachagua, where the petitions were consolidated. So that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour, or 30 minutes or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware, we are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise this issue, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday, who are not notified again, you know, those kind of issues. That's why we are wondering why the rush. Yes, maybe.
Yeah, on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm in it, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fairly. Yes.
Your Lordship, in the limited time that you serve, your name please. My name is Gachagua. Within the limited time that we sat with my learned friend, Mrs. Kimotho, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we do not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional law classes, which we have the privilege to be tutored by Senior Counsel, Professor Gitu Muigai. He told us that there's a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled by a person who does not enjoy the people's power to empanel a bench.
My Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchella case, one thing you learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchella case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchella decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly, who is a respondent today. It is the Senate, again, who is a respondent today, urging you to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice cannot perform this function. And on the basis of that, kindly stay the proceedings before the High Court. I'm referring to Nairobi Court of Appeal, civil application, number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, an arguable point of appeal is not one that will ultimately succeed. The point intended to be argued, whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court is not an idle one. It's not an idle point. It is an arguable point. The court, on the nugatory aspect, stated that on the nugatory aspect, it appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered the third aspect, which was introduced by the Supreme Court in a previous decision, the public interest consideration. And they said, we find also that this is a matter in the public interest domain, and it is proper that the appellant exhaust the appellant's rights. So the court went ahead and said that the motion succeeds and stayed the proceedings in the High Court. And to date, the state. And the appeal was supposed to be determined in a certain period of time. The appeal is still pending. And the proceedings in the High Court are still state. So, you are at the place where the 5-judge bench found itself. It made a determination, it was stayed. So today, we do not have any decision where the empanelment by the Deputy Chief Justice stands. Therefore, before we proceed in these matters, kindly find that the Deputy Chief Justice does not have power to empanel a bench of an even number of judges to hear the matter. Thank you very much.
Your Lordship and my lady, within my pleasure, my name is Sakimpa. I act for the third petition in this consolidated petition, which was Kerugoya E014 of 2024. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a prisoner's tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice, on 11th of October 2024 for empanelment of a bench. Your Lordship, the same has never happened until the conservatory orders in petition E015 were granted. It therefore shows, Your Lordship, that petition E014 as consolidated E013 are here to seal the loopholes so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend. That is my submission.
Hearing of matters during night hours. The answer to respectfully, my Lord, that judges can hear matters at all hours. I have done so. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Chief Justice Simpson These would be cases with simple matters, like individuals who want to bail at night because probably they have been in the bar, they have drunk a lot, and they want to bail. You rush from the judge's home or the chief justice's home, and you would grant a bail. It's a beautiful custom, beautiful practice, and I invite you to respectfully, my lords, that you endorse it in your ruling. It gave justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, still minors, in the West, our local girls, and you want now to fly out with these little children at odd hours. They want to get to work, they want to get to the ships at odd hours, and you rush to a judge at night, and he will give you an order, and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications, like telephone directories, their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and he would grant you orders. We no longer have that type of thing at all. I wish it could be reinstated. It was helpful. It handed down justice to the court. I recall one judge I appeared before, and I think he had me talking to his askaris at night. And he came out, shouted, "Who is that?" Somebody said, "Oh, it's a Kaminwa. He wants to come and be heard." And they shouted at me and said, Halima, I want you to know I'm not a judge during the day. I can't hear you, the time is over. And I returned and told him, Judge, the word would be shocked to hear, or the country would be shocked to hear. You are only a judge during the day, and at night you are not a judge. My Lord, let us reinstate that person, say so very loudly in the ruling. But then, coming to the instant case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice, his powers are set out in Articles 147, 148, 149, 150, 151. He has enormous powers. If a person can become a president of the Republic at any time. Your Honor, if you're going to hear his matter regarding impeachment, you should hear it during the day and it should be heard in the parties. It's not a matter that can be heard at all. What the Deputy Chief Justice or whoever it is would have done is to get on phone, to get in touch with the attorney general, get in touch even with the advocates, and ask them, can you come? But it should not have heard this matter expertly. This is not a matter that can be heard expertly at all. And then also when you look at the Constitution, and what the Constitution seems to be very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. If you permit me just read it to the court. It says that, not 165, Article 144, sub-Article 4, my Lord. Article 144, sub-Article 4. It says that 144, Article 4. So first, yeah, if you look at that 144 of Article 4, 144. Yeah, thank you very much. If the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly, Your Honor, where the Deputy Chief Justice can act, it is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer Your Lordship to impeachment provisions relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is, if you could look at Article 165, Article 4, 165, sub-Article 4. 165, sub-Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the Chief Judges, he takes into account a number of things, my lords. You take into account the experience of the judge that is appointing. You take into account things like whether it would probably bring a conflict of interest. You take into account whether there would be objections from certain individuals and so on, but you not expect to do that at all. into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated to the Deputy Chief Justice at all. It is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And they would probably say that, look, why don't you have so and so, so and so, so and so, so and so, and you would actually assign the judges to hear such matters. I would emphasize, and I also keep myself with my other friends, that there has to be miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her, not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind in law. The issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people going to get? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. When they come to conclusion that look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are dealing with matters to do with administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the Deputy Chief Justice was probably preferred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their first kind dealings that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the executive and such things are so. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submission of my able friends. There is a word somewhere in our safety in the Constitution that the Deputy Chief Justice may perform functions or the duties of the Chief Justice in absence. Clearly, that refers to cases where the Chief Justice may be Justice may be sick or the Chief Justice maybe is involved in something that is cannot yet perform. The work and so on. Now, in this particular case, nobody has alleged to the Chief Justice for anywhere. Nobody has alleged to the Chief Justice on duty. And nobody was alleged anything that made it impossible for the Chief Justice not to carry out her duties at all. Again, I emphasize the question down your removal of the deputy deputy president as Dr. And it's something that is making a number of Kenyans entertain us for interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current account. Now, you can't blame her when such things are happening. You can't blame her to have come to the conclusion that the Almighty God and Lord Jesus Christ no longer supports the current government because of such things as well. I argue very strongly that you have full submission of my friend, Mr. Kibe, and his care colleagues. They are able to submission, and it is unbelievable. Thank you.
May it please the court, we will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and extend the proper respect that the court deserves. I am instructed by the Honorable our first female Attorney General, informed the court that she is here because Article 156 sub Article 6 enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the be it the judiciary or the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government.